Yep.
All right. Well, hello everyone.
Yeah.
So a big welcome to the handful of people in the room in our new and exciting COVID world that we live in. I'm Nick Commons, organising today, so thank you for attending, everyone. And thank you for everyone online who's listening in, no doubt, with their cats and coffee. So today we have the lovely Jason Harris here from Sydney Law School.
I don't think anyone's ever described me as lovely.
Oh, well, there you go. The less lovely Jason Harris, who
Students are doing their exam tomorrow, so I don't know if they'll think I'm lovely.
Yes. So if you're Jason's students, tune in, and don't do your exam. Today's topic is the small business insolvency and the restructuring reforms, which are coming to a legislative paper near you, and apparently Jason's PhD as well. So we'll be looking forward to all of that. I won't talk for too long, but for those listening in on the stream, as mentioned, there is a Q&A that's open. Please feel free to ask any questions. I'll be sitting there looking at it and calling them out to Jason as they pop up. You are on a 10 to 20 second delay behind the real world, so there may be a chance that we answer your question before you even ask it. Otherwise, this stream is being recorded. We may be able to make that available later on, so that's exciting. If you have any technical difficulties, please let us know, and otherwise, please enjoy.
Thanks very much.
So thanks very much to Nick and to the partners at Hunt&Hunt for inviting me today. I think this is the third talk that I've given here over the last couple of years. So it's always nice to come back. And Nick did give me the option of just dialing in from the office, but I, like everyone else, is suffering from Microsoft Teams and Zoom fatigue. And I thought, wouldn't it be wonderful to go and talk to actual people? So I'm pleased that there's some people in the audience today, and hello to everyone who's online as well. So my name is Jason Harris. I'm Professor of Corporate Law at Sydney Law School. I've been thinking about insolvency and restructuring reform, including reforms relating to small businesses, for the last 8 years, because I'm doing a PhD looking at how voluntary administration works and whether it works well and how we can improve it at Adelaide Law School. And I've been doing that for the last 8 years, and I've promised my wife that I will actually finish it this year. So this is something that I'm really interested in, and it's kind of funny in that one of the things that I've been doing in the PhD is talking to a lot of practitioners, talking to a lot of creditors, lawyers, IPs, directors, advisors, turnaround managers around town. And one of the things that I was pitching to them last year when I was doing the interviews was the idea of a kind of modified debtor in possession regime for small business. So it's kind of a bittersweet moment for me on the 24th of September when the government announced they were going to introduce it, because I thought, well, this is great. This is what I've been thinking about for a while and pitching to people. But then when you actually get into the detail, the detail that's actually available anyway, you start to see where perhaps some of the gaps are. So that's certainly something that I'd like to talk about today, both what I've been doing in my thesis, which is about voluntary administration, and perhaps how that doesn't work as well as it could work for SMEs, and then also to go through the recent proposal. Okay, so what I thought I'd do over the next 2 slides, I've just got some statistics that I've pulled out from various sources, mostly the ABS and ASIC reports. And I thought if we're talking about small business, it's useful for us to think about what that means. And certainly I've been through some of the submissions that have been made public on the Treasury's announcement, and a few of them have pointed out there's really different views about what a small business is. How small does a small business need to be? So I thought we'd start on the positive side. These aren't necessarily the insolvent small businesses. So this is just ABS, Council of Australian Businesses data from earlier this year. So I won't read through all the statistics. Perhaps if I was to try and summarise them, we might say the vast majority of businesses in Australia have relatively low annual turnover. If we think about, for example, in the Corporations Act, the definition of a small proprietary company has, I think, 50 million in annual turnover as its ceiling. So the vast majority of businesses are well below that. And indeed, a significant proportion of businesses have less than 200,000 in annual turnover. And I think it's important that we start with that point, because when we talk about restructuring, we need to remember that there has to be something to restructure. There needs to be a viable business there. And if you combine what appears to be the case, businesses that are perhaps not always the best run in terms of their internal bookkeeping, monitoring their financial position, keeping control of their costs, so that they can become aware of problems early enough to actually fix them before it's terminal for the business, having relatively low asset bases and having a relatively weak market position, you start to say, well, what value is there to be restructured here? And I think we need to bear that in mind when we go through the 96 pages of proposed reforms on small business restructuring, which we'll talk about in a minute. One of the things that the ABS tracks, it's the Council of Australian Business, including entries and exits. Now, it doesn't differentiate between companies and other business structures. It's just talking about businesses in general, but it does offer us some useful insights in terms of businesses that have lower turnover fail at a much higher rate. Businesses that employ no people, and noting that's the majority of businesses in Australia have no employees, also fail at a much higher rate, and that those presumably larger businesses that employ hundreds, if not thousands of people, fail at a much lower rate. If we then look at the information at the bottom of the slide, and I've pulled out a fair bit of data from the ASIC report, 63% of reports that were submitted in the last financial year for which data is available reported no money being owed to secured creditors at the time that the report was submitted. And again, I'd really highlight that, because one of the things that I've certainly criticised the proposed reforms as doing is overcooking it. And when we look at the proposed new 5.3b, which is the small business restructuring proposal that I'll explain in more detail in a moment, one of the things the government has done is tried to mirror voluntary administration as much as possible. For those who are insolvency practitioners or insolvency lawyers, you would know that Division 6 and Division 7 of Part 5.3a contain very detailed provisions that specify what different types of creditors can and can't do, what different types of property owners, lessors, secured creditors can and can't do. And there's a multitude of exceptions, what's in and what's out. And they basically copied those divisions into this new procedure. And staring at that statistic, it just makes me think, for what gain? The more provisions that we put into this new procedure, the more complex it becomes, the more likely the small business person will need to get more advice, particularly legal advice. And the more, I think, it just becomes not all that useful for most small businesses. It's just too hard and too complex. So an overarching theme of this discussion, at least in terms of my view, is that the government has said that its debtor in possession, has said that it's going to be streamlined, has said that it's going to be simple, quick and cheap. And really what they're delivering, at least on this initial draft, is a VA light. That'll be a little bit easier, a little bit quicker, and a little bit cheaper than voluntary administration. And as you'll see in a moment when I present some of the data from my PhD research, that will still mean that the vast majority of small businesses won't find it useful, because it will still be too expensive for them. So again, it makes me think, well, for what purpose is this? There's also the statistic there at the bottom in terms of the Australian Bankers Association report from 2016, so it's a couple of years ago, but just noting that it's a relatively small number of small businesses that even seek external finance. Now, in that report, they didn't break it down into things like PPSR registration. So I wonder if they're just looking at, say, external bank finance as opposed to a supplier finance where you've got PIMSs and the like, but still that's a relatively low amount. Okay, so then let's go to the other end in terms of insolvency and small businesses. So these are based on the what used to be the Schedule B EXO1 reports, now the initial report, and ASIC. I pulled some of this information from the time series and some of it just from the FY 18-19 year. I've been tracking this for a few years. I've done a few posts on my blog about some of this data over a few different years, and the numbers are pretty similar in each year. So I'll run through a couple of these. Again, we see the vast majority of companies have very few employees, which is consistent with the non-insolvency ABS data. we see relatively low levels of assets. And that first figure there on the second line, at appointment, 78% of companies that had reports lodged for them, and with this one, I think it was about 7,500 companies, had assets of 50,000 or less. So if you've got 50,000 or less, that's not a lot to work with in terms of trying to restructure. And if we assume that this new procedure is going to cost, I would have thought, at least $5,000 or $10,000, you know, that's potentially 20% or more of the assets of the company. That starts to sound like an incredibly expensive procedure for what is actually there. And one of the things that was interesting when I was doing interviews, and it's well before this stuff was announced, but when I was doing interviews and I was talking to an insolvency practitioner who mostly does small jobs, small companies, and had done quite a lot of VAs over the years, and told me that essentially he hardly does VAs now because most of the businesses that he's appointed over, there's maybe one viable asset. The director's probably going to buy it back because no one else is going to value it as highly as they do. And he said his standard advice is, why do you want to go through a VA? It's going to cost you $40,000 or $50,000. I'm going to have to do all these investigations and reports. We'll just put it into a voluntary liquidation. If the end result is just going to be selling the asset, that's in essence what you're doing. The VA is really overcooking it, and I suspect that this new procedure similarly will be overcooking it. In almost 60% of reports, estimated assets were 10,000 or less. So you would assume that the vast majority of these companies, this new procedure is simply going to be too expensive. Even charging 2,000 or 5,000 is still going to be too much for these businesses to pay. Which, you know, as I get into these figures and I look at the, you know, literally dozens and dozens of new provisions that are being proposed in the Act and who knows what in the regulations, you just wonder, does the government actually think that a lot of people are going to use this? And I'm not sure that they do. You know, maybe there'll be some companies that this will be useful for, but the idea that this is in any way going to deal with the so-called tidal wave of insolvencies as zombie companies is just nonsensical. It won't.
Jason, I think
Yes.
you make a really interesting point. A lot of those asset and liability figures, they've been fairly stable over a number of years as well. So to try and get some change in thinking at the director level seems exceptionally difficult or challenging because of the length of time that we know those figures are broadly consistent.
Yeah, and we keep, you know, I've been teaching insolvency law for I think 17 years now, and one of the things that I keep seeing is we keep adding to the regime without actually thinking about how the regime works and how it could work. And to build on your point, Bruce, if directors are essentially trading the business until they're forced not to, often by ATO enforcement action or some other creditor taking enforcement action, and we end up with, they've got 10,000 or less in assets, the problem isn't so much the insolvency system that's driving low returns for creditors. If the pie's tiny, no one's going to get a big slice. So how then do we encourage directors to take action earlier? And the problem is our approach to insolvency law and restructuring is really to leave it all at the back end. It's all about dealing with the mess rather than preventing the problem in the first place. And so we end up, if we think about the ATO as an example, you end up seeing these companies that end up with 10 or 15 repayment arrangements. And you think, what's going on here? Now, maybe the ATO would say, well, hang on, if we take enforcement action against small business, we get Kate Carnell on our back, we get the Four Corners report saying how bad we are, ruining all these small businesses. But if someone needs 15 payment arrangements, it's just not viable. And we just don't seem to be able to face up to the reality of these businesses, which is that most of them are fundamentally unviable. So then the question becomes, well, what do we do with those? And I think the major failing of this proposal is the answer is there's no answer. There's no proposal to deal with that problem, that any viable restructuring is going to have some assets. So either the directors are putting their hands in their pocket and providing an additional fund for creditors, maybe they'll do that. They're getting some protection. There's some discussion on a later slide about that. But the businesses that were probably insolvent before COVID and have just spent the last 10 months without fear of insolvent trading and without creditor enforcement, they're not in any better shape. So there's nothing in this proposal to deal with those, and I think that's a fundamental failing. Even the levels of liabilities are reasonably low. 38% owed 250,000 or less. As you might be aware, the Treasurer said that the ceiling for liabilities for these companies to use the new procedure would be $1 million. That's still a relatively small number of these types of companies. Now, I won't read through the rest of the statistics, but there is one that I really want to focus on. It's this one. So it's the estimated returns. We often hear in discussion about the nature of Australian insolvency law that, in the vast majority, creditors get 11 cents in the dollar or less. And I think that's really a misleading statement. Because while it's true, the reality is far worse. Because when you look at the actual breakdown of how many got between 0 cents and this number and this number and this number, it's 92% get zero. So to say 96% get 11 cents or less, well, not really. 92 of that 96% get nothing. And one of the big issues that we have in insolvency, it seems to me, is that we've designed an incredibly elaborate system to provide maximum transparency for creditors, maximum information for creditors, maximum participation rights for creditors. And I would say, aren't creditors rationally apathetic? In the absence of repeat players like major leasing companies, major hiring companies, the ATO, major insurance companies, surely creditors are mostly rationally apathetic. And if in most cases they get nothing, why would they want to participate in any of these processes? And it was very interesting. I spoke to a number of creditors, both small creditors and large creditors, as part of my PhD interviews. And one creditor of a very, very large company, when I asked them, I said, what do you think of the quality of, administration reports or turning up to meetings? And they just basically said, well, we never read them. Why would we? We've never been paid in an administration. We don't expect to get paid in administration. Why would we waste any time engaging with the process? And I think that's an issue that we have, is we've got a system that depends upon, the focal point is the creditor. It's all about the creditors. Even the Treasurer is saying these reforms are all about increasing returns to creditors. If you've got 10,000 or less when the process starts, creditors are getting nothing. And that's what we see in the vast majority of these cases. I've spoken to IPs who tell me that they think their client's the ATO because that's the only creditor that they ever see or hear from. So I think we've got a problem there. It's a structural problem with our regime, that it's this very ornate system with a whole lot of inbuilt costs that, from my perspective anyway, serve very little purpose. And there's also, as IPs would know in the room and online, there's a very high level of unfunded work. Now, the Deloitte report that I've referenced at the end there, I'm not sure how much of an accurate assessment that is. I guess it could be that. If it is that, then I'm not sure that we do have the resources in place to effectively deal with that as an external administration or a debtor in possession model. If we have 250,000 companies going under, I don't think we can deal with that. I suspect what we'll have is what we've had for a long time, which is large numbers of companies being abandoned, whether through an illegal phoenixing or not. Just as an example, the other day I went through and had a look at ASIC's insolvency notices website, and I wanted to see notices on the deregistrations that ASIC had made based on a request by the company. And you can't get them all at once. You basically have to click through, and there was an awful lot of click-throughs, but I got to the end of it so that I could get the total amount. Since the middle of 2012, which is when insolvency notices came in as a website, on average, we've got about 60,000 companies are voluntarily deregistered every year. So that's not the ASIC has written to them and there's no response and then ASIC deregisters. That's the voluntary deregistrations. And you think, what's going on there? Is ASIC reviewing any of those files? Probably not. So a fundamental problem with these reforms is, where is the incentive for the directors to do anything more than nothing?
It's interesting you raise that point, Jason, because there was an ASIC sort of liaison meeting with insolvency practitioners yesterday, and that question was raised with ASIC, both around voluntary deregistrations and the involuntary ones. And we said, look, is there any sort of joint venture, for want of a better term, that ASIC's going to have with the ATO, probably as one of the major creditors in a lot of those companies, to look behind the corporate veil and see that there aren't director loan accounts that otherwise are being sort of just written off as part of this process, or what? And the answer was no.
Yeah. And I suspect it could be a resourcing issue, but it could also be that they don't want to know the answer. So I think it's very convenient for ASIC to see IPs as gatekeepers, because then when things slip through the net and there are examples of gross misconduct and law breaking, ASIC can say, well, the IPs didn't tell us. They didn't give us enough information. It's convenient for them to deflect that responsibility onto someone else. So if they actually went through and found out, oh, actually, there's thousands of companies every year that are not supposed to be being deregistered, but are, because no one's looking at them. No one's complaining about the deregistration process. And, you know, how does that affect creditor confidence in the system is one point. But someone should be looking at some of these processes, because, you know, we talk quite a lot about phoenixing and, you know, pre-insolvency advisors and these sorts of things. The hardcore bad guys know this system inside and out. They know exactly how likely it is that they're going to get caught. So that's not who these new laws are affecting. It's those who aren't fully across the new laws and get caught up with things like creditor defeating dispositions and notices from ASIC. Oh, we think you've engaged in a creditor defeating disposition and we think you've made this much money out of it, so you have to pay that to us. And if you don't, it's a criminal offence, and good luck challenging it. We end up with those sort of laws, and this is just adding to the complexity of the legal system without necessarily a lot of tangible benefit, at least in my view. Okay, so then my doctoral research, as I say, at the University of Adelaide, I'm looking at 3 different types of empirical data. So one is a statistical study of 5% of all voluntary administrations each year in the first 25 years. And what I've done is identify 17 different variables to try and track what an average VA looks like. Now that's only using publicly available information, so I don't have any of the financial details of those companies. But that does allow me to track things like how long does administration last for, what's the typical outcome in administration, if you go into a docker, what's the outcome of the docker, those sorts of data points. I also did a survey several years ago, which Bruce, you gave me some advice on through the Insolvency Committee of CANS. So that was looking at a couple of hundred accountants and reader members, and then I've done 40 interviews last year with a variety of senior practitioners. So the cut-off limit must have been 15 years plus in terms of practice. And those interviews covered people working at the small end, the medium end, and also the very large end. So some key points that I took from that was, in terms of the statistics, the vast majority of VA cases, at least in my sample, were completed within the standard timeframe. So one of the things I went into the research wondering was, is the timeframe in voluntary administration too short? And if we compare it with things certainly like Chapter 11 administration in the UK, it's much shorter than that. And yet most of the people that I spoke to said, well, yeah, in large jobs, of course, it's not long enough and we by default go off and get extensions. But a lot of the smaller practitioners I spoke to said actually having a tight timeframe is useful because it can bring parties to the table. You don't have a year to deal with the issues. Also the fact that the vast majority ended in a voluntary liquidation, but people that I spoke to in the interview said that's not necessarily a failing because maybe there was a sale of the business as a going concern, in which case it's still achieving its aims. Of those that did go into a docker, I was surprised to find that the majority of dockers were terminated because they'd fulfilled their goal rather than being terminated by the creditors or terminated by the court. I also saw very little, at least in my sample, and the sample was about 2,500 companies. I saw very little evidence of kind of auto-terminating creditor trusts. So most of the dockers lasted for at least 6 months, and the average was about 18 months. One interesting thing I found looking at the data was the level of deeds of company arrangement over the first 25 years have been largely static. So there was, I think the top was maybe about 630 dockers in that year, but we've seen pretty much a very large bell in terms of VA appointments, peaking in about 2004, but the level of dockers has been roughly the same ever since they started. I think it was the second or third year we got to about the 350 level. And what that suggests to me is that there is a type of situation, a type of company that a docker is very useful for, and that's been consistent all the way through. And that perhaps the big spike in administration numbers was really more about director penalty notices, because certainly we've seen a massive drop off since 07. And similarly, we've seen a massive increase in CBLs. And the other thing that it showed me, because I did look at where there had been an overlapping appointment of a receiver, is that was pretty low. It was only in about 11% of the matters in my sample. Okay, in terms of the interviews, a variety of views. Most people I spoke to believe that VA worked reasonably well. Most of them agreed that there could be some improvements, but most people said it worked really well. Some people said they thought it was fantastic and far superior to what there was on offer in places like the United States. A couple of small practitioners told me that they thought it was terrible and they actively told people not to use it because it was far too expensive. But most people were saying it's a very flexible regime. There's a lot that you can do with it. One senior practitioner who works almost exclusively on large matters said that, you know, it's so flexible, we're really only scratching the surface of what could be achieved in terms of commercial outcomes with the VA and DOCA regime. A lot of people said that it's quite useful in dealing with problematic leases. And I did ask about safe harbour and also ipso factos, but most people said it was too early to tell on that. I did also put to people whether we should look at imposing restrictions on receivership, because we saw that happen in England many years ago. Some people supported that, particularly some lawyers, but most of the others said that probably wouldn't work in the Australian market. So in terms of disadvantages, and these are really things that I'm focused on in terms of law reform recommendations in my thesis, reporting obligations seem to me to really stick out. I've seen administration reports that are 100 pages long with 30 pages of remuneration disclosure. When I was talking to creditors, like I said, most of them said they never look at it. There was pretty broad support for saying, why don't we just have a standard kind of pro forma type advice, which is not to say that the further data shouldn't be collected, but just whether that needs to be reported in the current format to creditors. I'm just not sure that giving creditors a 100-page PDF document or a physical document is all that helpful. I'm not convinced that they actually find that useful. So in which case, you know, that contributes tremendously to the cost of the procedure. So I think we could save some money there. There was general agreement that the cost of administration, if we assume it's about $40,000 to $50,000, although one IP said that he actually laughed when I said that was what people were quoting to me. He said, oh, I reckon you can do it for much less than that. But that was pretty consistent. And so most people agreed that's going to be too expensive for most SMEs. It was interesting though, then when I pitched to them the idea of a streamlined SME procedure, there was really mixed views about that. So a couple of people said to me, the problem is every time we add something new, you're just adding further complexity. So if we think that we need to save money on the structure, then we should save money on the structure rather than adding something new, because there's a whole lot of uncertainty. It takes years for the court decisions to come out. It's a lot of uncertainty into the marketplace. A lot of people complained about constraints on sale processes, and one of the things they acknowledged is that was not necessarily legal based. You know, we might say, well, we got some evidence of that in terms of what's been happening with Virgin lately, which is certainly not an SME. But the fact that you can sell the assets relatively quickly, you don't need to wait till the final creditor vote. But there are a lot of people who are saying, you know, particularly those who've worked in the UK market or worked in the US market, that there are more efficient processes we could use. And the other thing that a lot of people said was they don't see a lot of evidence of actual restructures and rescues, that mostly it's about asset sales. And again, I'm not sure that that's a failure of the procedure. That's pretty consistent with restructuring procedures overseas. So the so-called liquidating CCAAs in Canada now are dominating, which is basically just an asset sale. 363 sales in US Chapter 11 cases are far and away the most common outcome there rather than a confirmed plan, and of course the pre-pack procedure using administration in England. So that reflects global practice, certainly for the larger jobs. Focusing particularly on SMEs, what became very clear in the interviews was that even though there are inbuilt cost structures in administration, people that I interviewed were saying that in and of itself isn't the real problem. The problem is the poor financial position of the businesses when they get to it. You know, the idea that the doctor can't save a patient who's already dead on arrival. So we really should be focused more on trying to help directors earlier in the decline curve rather than assuming that even the most streamlined and cost-effective procedure is going to be enough to save out what is already a dead business, which, as we see in those earlier statistics, is often the problem. A bigger problem that I think we're going to have, if we don't already have it, is this idea that a lot of the businesses are in such poor financial condition, they're just too poor to go broke, so they just get abandoned. My co-author, Michael Murray, has made the point to me many times, questioning why that's a problem, that if we've got a system that says if a company's insolvent, then someone should wind it up, and that generally should be a creditor, and the creditor should put their hands in their pockets and do that. And if no creditor wants to do it, Michael says, well, is it really a problem there? And I think it is, because again, we've got this idea of the creditor's respect for the system and their confidence in the system. And of course, we've also got the problem for those small numbers of businesses, as we saw on the first slide, that actually have employees. If the employee entitlements aren't covered, then of course they can't access FEG if the company doesn't go into liquidation. So yes, I think we should be dealing with zombie companies. We shouldn't just leave a graveyard of abandoned companies. I think that would be a poor policy outcome. What other issues? I mean, in terms of SMEs, again, the IPs on the line and in the room don't need to be told about the unique features of SMEs, but I think there are enough features to justify its own special procedure. And I think a modified debtor in possession regime is a good idea in that it will deal, hopefully, with the loss of control, family sentimental attachment issue, because they do maintain some level of control over the business. But there's so many other problems that we need to grapple with, particularly around personal guarantees and the intermingling of personal and business financial assets and debts. And I'm not sure that the current proposal adequately does that. Now, the point that I've got at the bottom there is, I think for a long time we've relied upon an idea of what our insolvency system does and what it achieves, and that's in stark contrast to the reality. I think that we perceive as a community that we have effectively a Rolls-Royce system of maximum transparency, independent, experienced practitioners, you know, strong codes of ethics, strong regulation. All of that comes with a cost. And if we're starting with almost nothing, then it makes sense that the outcome for most creditors, most of the time, is nothing. And I'm just not sure that that's a successful procedure. If we're saying that insolvency really isn't about creditors at all, it's not about creditor returns, it's about transparency and accountability and process, then I must say that my reaction to that is, well, do we need a private profession to do that? Is that really the best way to achieve that? And certainly, I think we need to fundamentally rethink the balance of public and private funding of insolvency, because that's gone seriously out of whack. If we've got a system where a large proportion of jobs go unfunded, there's a large proportion of work which is unfunded. That's just an unsustainable system, particularly if we end up with another 100,000 businesses needing to go through it. Okay, so law reform proposals, getting to the proposed reforms. These were the Small Business Family Enterprise Ombudsman's suggestions. There were a few others. I think it's interesting that the government has picked up on the simplified liquidation idea, although the amount that was suggested there and the effect on secured creditors has not been adopted, but the simplified liquidation has been. The Directors' Insolvency Agreement, I don't think has much support in government. And what we're dealing with here, in a sense, are the two competing aims of trying to provide something that's quick, cheap and effective to deal with an economic problem versus concerns about transparency and Phoenix activity and people avoiding their obligations. So I'm not sure that the Director Insolvency Agreement would get up. So in terms of debtor in possession, I'm not going to go through this slide in detail. And Nick, I assume you can send the slides to all the attendees. So just what I thought I'd do here is just, for those who aren't familiar with debtor in possession, we've all heard of Chapter 11. I think the idea of Chapter 11 is, in Australia anyway, is kind of the Disney idea of Chapter 11 rather than the reality of Chapter 11. The government, of course, has said that this new regime is going to borrow elements of Chapter 11. I'm not saying that's misleading, but the only thing that this new regime shares with Chapter 11 is that it's called debtor in possession. And when you go through a lot of the detail, I think we run the risk of this not even being a debtor in possession, but this really being a small business restructuring practitioner in possession. And that, of course, is just going to drive up a lot of the costs. But one of the things that I wanted to do here was go and look at different studies of different debtor in possession regimes around the world. And what we can see is that, at least with some procedures, and it tends to be where there's larger companies and larger asset values, the returns can be pretty good. So where Chapter 11 works, it works really well. It just doesn't work for more than about 30% of cases in the US. And even that's still coming on a pretty small base. So in terms of Chapter 11 cases, about 6,500 cases a year. So, less than 30% of those would have confirmed plans. Probably about 2/3 of those confirmed plans would then avoid a subsequent bankruptcy. And of those, it probably works quite well. Similarly, in Canada with the CCAA procedure, 30 to 50% return for unsecured creditors, although selling the asset as a going concern is typical. If we look at the other end of the market in terms of CVAs, the typical rate of return on CVAs is pretty minuscule. It's about, I think it's about 4 cents in the dollar. It's pretty small, and most of them fail. All right, so here's the purpose of the new procedure. The government recognising that a one-size-fits-all VA perhaps isn't always appropriate. Encourage more small business to seek debt restructuring earlier, increasing their chances of recovering viability. I don't disagree with any of that. I'm just not sure that the proposed laws will actually achieve that purpose. I'm not sure that there's really anything in it which is going to encourage directors to say, yes, we totally want to do this. We were hesitant about voluntary administration, but this is the regime that's going to fix our problems. I'm just not sure that that's right. So it is a debtor in possession regime, but basically what that means is the government's taking the view that that only operates if you're working the ordinary course of business. Now, in the explanatory memorandum, or the draft one, the discussion of ordinary course of business means you're running the business in almost exactly the same way. They actually give an example where they say, if this business has to start selling assets, plant and equipment to pay debts, then it's no longer trading in the ordinary course of business, and that means every decision needs to be approved by the practitioner, which means it's no longer debtor in possession, which also means the cost of the procedure is going to go up. How is that going to affect the professional indemnity insurance for the practitioner? If you're supposed to be, if you like, the guide on the side, who's just monitoring what's going on, giving a recommendation to creditors, and now all of a sudden you're being asked to approve every major decision that's going through in the business, even if you're protected against personal liability, so there's no liability for the decisions that you give, that's still a lot of responsibility and a lot of time and resources, and that's going to drive up the cost. So the goal is simply to put a plan to creditors, and the current proposal is to vote 50% in value only, and there'd be no physical meeting. So it'd be an online meeting or maybe a circulating resolution. The public submissions that I had a look at from the large industry bodies were all recommending, as did I in my submission, that should be changed to 50% in value and 50% in number, not just 50% in value. Now, related party votes probably won't count, and there's different ways to look at that. I can see the benefit of that. We don't want this to be seen as a procedure where the directors are essentially handballing the assets to their relatives and related companies. But if we're saying we're trying to give directors control, and we're now saying, well, hang on, how are most of these small businesses funded? They're often funded through director loans. Well, actually, we're going to exclude all of that. So as one commentator has said, is this actually creditor in control? Because you're then putting the control back on, in terms of the vote, to the ATO and the general trade creditors, because you're excluding related party votes. A lot of the other regimes do exclude related party votes as well, so I can see the benefit in doing that. You're deemed insolvent if you put up a proposal. Now, the idea is this is only supposed to last for about 20 business days, and then you get a further 15 business days to conduct the vote amongst the creditor group. If we compare it, say, with the moratorium regime that's just been introduced into England, there's fairly similar timeframes there, but then there's the opportunity for more than one extension of time. So it'll be interesting to see whether the government adopts that, or whether this really is supposed to be a month-long proposal. Because if it is, if this is a short proposal that really only goes for a few weeks until the vote, then I just query why we need 100 sections to be inserted into the Act to deal with that. Why we need to replicate VA in what clearly is not a VA. The practitioner will need to lodge a DIRI, and the proposal at the moment is that they'd be a registered liquidator, but really this would be a new category of liquidator, and this is where we're seeing a lot of tension in the submissions at the moment. So liquidator bodies are saying, well, this should just be standard liquidators. Other bodies like the Turnaround Management Association, the Institute of Chartered Accountants are saying, well, maybe there's a broader skill set that could be brought to this sort of role. So it'll be very interesting to see where the government ends on that. I would just note, with the other restructuring procedures that we see in the countries that I had before, with the exception of the US, but certainly Canada and the UK, it's always a licensed insolvency practitioner who's doing that role. In terms of eligibility, so the proposal is for less than $1 million. It's interesting, again, in the submissions, we saw really different views on that. So a reader was suggesting that, you know, maybe that's a little bit too high. Others were saying that's too low. If we compare it again with the US, which recently introduced a small business Chapter 11 procedure, that's $7.5 million US as their ceiling. So I do wonder whether we should extend that. And as an overarching point, we might say, well, if we can create a procedure that is going to be quicker and cheaper and hopefully more effective in driving creditor returns and commercial outcomes, you know, why are we restricting this only to small businesses? And certainly the TMA in their submission was saying, you know, we should be looking at more flexible procedures for all companies, not just for SMEs. The third dot point there is a very contentious point, and pretty much all the submissions that I read from the major industry groups were saying this should be cut because this is going to mean that a lot of small businesses won't be able to use it. I think the government is pretty firm on this in terms of not wanting to be seen to be giving pre-insolvency advisors a free kick. So if you're a director who's doing this multiple times, then I think the government is going to stick with some form of that. What the Law Council put in their submission, which I was part of, is that we really need to think about how corporate groups operate, because you might have multiple companies which are using this procedure at different times, and then whether or not that should count. So I think we'll see some modification of that in the regulations.
Jason, we've got a question on the online.
Sure.
Robert asks, is the 50% in value those that are voting, or is it 50% of creditors of the company, ex-related parties?
So that's an easy question for me to answer, but the answer is unsatisfactory. We don't know, because that's all to be determined in the regulations. And even that 50% figure isn't taken from the draft law. That's taken from what the Treasurer said in media interviews. So that's the proposal. We don't know how that's going to be counted. So the employee entitlements and the tax lodgements, also I think the government is very, very firm on those. I don't think they're going to budge. And I think particularly with the employee entitlements, that's going to mean that the vast majority of businesses can't use it. So one of the things that I asked Treasury people when I was discussing these reforms was, well, hang on, if maybe you've made up your wages and those sorts of things, but maybe you're a bit behind in your super, why can't you then put in a proposal which makes that up during the proposal? And that was, you know, a very clear, no, that's not going to work sort of thing. So I think the government's very keen on that. And look, the cynic in me would say, this is about preparing the company to end up in a more favourable position for the FEG recovery program when it goes into liquidation. So if we force, before you can put a proposal, all these have to be fully paid up, at least what is due and payable, then it means if the plan is voted down or if the plan fails, you end up in liquidation. That's less money that FEG has to extend to the employee. So I think that's just my personal view, but I think that's what's behind it. Okay, in terms of the effect, like I said, they've basically copied the provisions in VA, which I think is seriously overcooking it. They've imported all the ipso facto protections. We don't know whether they're going to include all the exceptions. Again, I think that's just massively overcooking it. That's going to make it far more complex than it needs to be. And if this procedure of restructuring before the plan really is just a couple of weeks, I don't know why we need all of these different exceptions. It's just making it more complicated. There is protection for director guarantees, but just like in administration, it's only for the duration of the restructuring, not for the plan. And there certainly were a few submissions that were saying, well, that means it's not going to be very effective. So the government's saying that this is all about those who are running businesses, but related party debts basically aren't going to be counted for any control purpose. And you're not going to get much by way of protection for guarantees once you actually enter into the plan. And there's no consideration at all about how any of this is going to work with personal bankruptcy. There's no proposal there be any harmonisation there. There's no protection for the directors against tax enforcement, at least in the current draft. You know, I've got to ask a question, but what's in this for directors? Where's the incentive for them to use this? And if you say, well, maybe it's because they then get further protection for insolvent trading, I'd say, yeah, if I'm a non-executive director of an ASX 200, I'm very worried about insolvent trading. But if I'm running a small business as a courier or a baker or a carpenter, I don't think I think all that much at all about insolvent trading, because if this business fails, I'm going to lose my house. I'm probably going to get divorced. There's going to be a hell of a lot more serious consequences for me than maybe ASIC suing me in 5 years for insolvent trading, or maybe a liquidator in 5 or 6 years suing me for insolvent trading, where my response will be, you can't get blood out of a stone. So I'm just not sure that that's really attractive for directors. What else have we got here that I wanted to focus on? There's going to be something like 12 new relation back day calculations. So they're adding a lot more examples there. There's going to be potentially big changes with avoidable transaction proceedings, but again, we don't know exactly how that's going to work. What can you put in the plan? We've got no idea. When will the plan end? We've got no idea. Exactly how will it affect creditors? We've got no idea. All of that's to be determined in the regulations. Similarly, what are the duties and expectations of the practitioner? We don't know. That's going to be in the regulations. There's some things which are listed, and there's kind of inconsistent things in the explanatory memorandum. So some of it is really saying they're not running the business because this is debtor in possession. They're there on the side. They're just reviewing the plan. They're providing what they're calling a certification to creditors, and a lot of the submissions are critical of calling it that. But then there's a whole lot of stuff about the practitioner actually is going to be approving transactions, that a lot of things have to be put to them for them to review. You know, the certification point, they're deemed to be an agent of the company. Why do they need to be an agent of the company? If it's a debtor in possession regime, they don't have management control. Any debts that are incurred, they're not responsible for, unlike an administrator in VA. Why are they the agent of the company? So it's all quite odd. They are going to be an external administrator for the purposes of the IPS, which means all of the Division 20, Division 40 stuff in the IPS is going to apply. Division 90 court orders will apply, although the reviewing liquidator power won't be applied to them. They're also going to be an officer, which I find a bit odd, because then their duties to the company, whereas certainly in my submission I suggested they shouldn't be an officer, but they should have a duty to act in the interest of creditors as a whole, because that's who the plan really is supposed to be promoting. Right, so summarising then, maybe they get a bit of protection, maybe it will help some businesses, but I think there's a lot in here which is not all that favourable, and that point that I've got in bold there, you know, I don't see any incentives here for directors all that much. You know, maybe there's the odd case here and there, but the vast majority, I can't see how it's going to help them in its current form. Help them any more than just going and appointing a voluntary liquidator. Now, I'm giving a plug to my blog there, AustralianInsolvencyLaw.com. I posted up a post the other day saying that I think the problem in this regime is that it's lacking a filtering role, because if you're going to see an insolvency practitioner to advise on these different things, the problem there, I think, is you need someone much earlier in the process before the company's in serious financial distress. So I've advocated that we need to have a kind of GP role where you think the company might be a bit sick, so you go and see someone who's a generalist who can give you some advice and maybe say, well, yeah, your business is cactus, you should go straight to liquidation, or maybe there's a chance, or maybe we can go off and see the small business ombudsman and get some mediation or something with the dispute that you've got with the tax office or something. So I think we need that sort of role, and absolutely supporting the ombudsman's proposal for a business viability review, where the government essentially would provide a minimum amount of funding to facilitate that. Now I notice I've just gone over the hour, haven't I, Nick? Is that right? I'm okay. Okay. Sorry, I was looking at the clock on the screen here. So in terms of simplified liquidation, I wish I could talk more about this, but unfortunately, almost everything is to be determined in the regulations. So we don't know what it's going to look like. We know that the government is proposing to harmonise the eligibility requirements with the new small business restructuring proposal. So there should be some sort of transition from one to the other, but we don't know exactly how that's going to work. We are not sure exactly who the liquidator is going to be. So, for example, if you've got this new category of liquidator that is running the restructuring, can they then take a simplified liquidation? And I think most people are assuming no, unless they're also a standard liquidator. And then, of course, there's some discussion, which was in the ARETA submission and other people have been talking about, in terms of independence requirements. If you've been in there as a small business restructuring practitioner, effectively approving transactions, which you have to do if it's outside the ordinary course of business, it's difficult to see how you can comply with independence requirements then, because it's not like a Channel 10 type situation where all you're doing is supposedly monitoring the financial position of the company before you take the VA appointment. This is, you're approving transactions, which could then come under review if we've got voidable transactions. So I think that's a tricky one to see who the liquidator is going to be there. But this is where we see such a clear tension between the competing goals here. If the goal is quick, cheap and effective, we've got a big problem in terms of volume that we just need to deal with as quickly and as cheaply as possible, then it makes sense to say it's the same practitioner. But that comes at a cost, and the cost is the concern about independence and the concern that transactions are just going to get slipped under the rug, that there's not going to be full transparency. So supposedly there's going to be no 533 reporting. But there's nothing in the explanatory memorandum that says any other reduction in reporting. And what a lot of people have been saying about this and whether it will be effective is, you know, a little bit like the restructuring plan, this is just a little bit less complicated than a liquidation, a little bit cheaper than a liquidation. But I mean, there's people around town saying they can do a CVL for about $8,000. I mean, how much cheaper can we make it while still making it a credible process? So unless the government is going to completely strip out all reporting, and effectively this is just waving companies into deregistration, I just don't know how this is going to be much cheaper. They're saying, oh, but there'll be no meetings, but then there's basically no meetings in CVLs anymore anyway. So I'm unconvinced about whether this is going to be all that effective. And the other thing I'd say is, if we can make liquidation cheaper because we're worried about creditor returns, let's make all liquidations cheaper. Why are we restricting that to small business? Okay, almost finished. I've got 2 more slides. So other potential reforms, for me, it's all about the cost structure. How can we try and reduce the cost structure, reduce the complexity? So there's some things that I'm looking at in my law reform chapter in my thesis around electronic presentation of data, whether we need to present a massive report or whether perhaps we can present that in different ways so that creditors actually are kind of shepherded into the sort of information that they might actually find useful. And perhaps starting with just a pro forma executive summary, and that's what every creditor gets. It's a 2-pager. Here's some boxes that you fill out, and then the rest of the information basically is in the cloud. And if you're a creditor, you log in and you're basically shepherded through with a series of automatic questions that will then point you to the right information, rather than everyone gets the standard data. It just seems to me it's a bit like prospectuses. You know, you put everything in because you don't want to get criticised by the court for leaving something out. And I'm just not sure that that's really all effective. Certainly there's some issues around the role of the court in administration, and one of the proposals that I got a lot of support for in the interviews was, you know, why do we need court approval to extend the convening period? It just doesn't seem to me that that serves much of a purpose. Try and find a case where that's been rejected. So I know of one about 10 years ago in the Victorian Supreme Court, but pretty much every other case they shepherd it through, or they say, you're asking for a year's extension, well, we'll give you 6 months and you can come back again if you want another extension. So let's just let creditors do that rather than going off to the court. Should we facilitate fast track sales? I think we should. You know, I think administrators, there's a lot more that they can already do that perhaps cases that we've seen recently like 10 Network, Virgin and CFolly are revealing about how flexible the regime is in terms of making commercial decisions. The really big gap in this new regime, which really is not going to help small business at all, is they're not facing up to the trading trust problem. So the fact that you can go into this liquidation procedure and then, oh, but hang on, some of these assets were being held on trust, which we didn't realise because the trustee was sitting in the top drawer and they hadn't looked at it for 20 years. And now all of a sudden we've got to spend $20,000 going off to the court, getting ourselves appointed as receiver for sale, which means, well, there was $30,000 in assets and now there's $10,000 in assets. Like, it makes no sense at all. Now, my colleagues at the law school who are trust law experts would vehemently disagree with that as a proposition. But I think if you're acting as a corporate trustee and you go into liquidation, the liquidation provision should apply, and we should amend section 477 to say that it covers property held on trust where there is a right of indemnity still in place. And that's what the Harmer report recommended 35 years ago. Promise the last slide, Nick. And really this is just some final thoughts. I think we've still got a very long way to go to just accept the fact that insolvency and business failure is not always the result of mismanagement and wrongdoing. Sometimes it is, but I think often it's the tail wagging the dog, and it's the bad example. I think far too much regulators, politicians, journalists, and to a certain extent practitioners are still very much in the shadow of Stuart Riff. It's one bad apple. To have a couple of bad apples over 30, 40 years does not mean that we've got serious issues in terms of the profession. And I think it just colours everything that we do. Every reform proposal which offers anything less than the maximum transparency is shouted down as a free kick to Phoenix operators. In my view, the Phoenix issue is a separate issue. If we had ASIC doing its job, if we had the ATO doing its job and Fair Work doing its job, we'd have the Phoenix issue addressed. It's because it's being deflected onto IPs that it just bogs all of this discussion down, and we basically get nowhere. And we just end up with more and more law and not a lot more effective law. And that second point, which I mentioned earlier, that we need to seriously address the balance of public and private responsibility. Because if we've got liquidators who are saying, I think my client's the ATO because they're the only creditor I ever talk to, then there's a problem in the system. It really isn't about creditors in most jobs. Sorry, that ended up being a bit rantish. Hopefully that's given people things to think about. I'm happy to take more questions if there are any, although I suspect I'm preaching to the converted.
Could be the case. This is your last chance, folks, if you're listening online in 10 seconds' time, to ask Jason a question. Otherwise we can stare at Jason for 10 seconds while time catches up.
It's so nice to talk to people in a room rather than staring at a Zoom screen.
Oh, look, I think we've got all the questions we're going to get. So thank you very much. We'll play a clapping sound from the Raucous Bunch. So thank you for coming in, Jason. It's always a pleasure. Thank you for everyone on stream who's joined us. Thank you to everyone in the room who's joined us. And we hope that this will be one of many, and once they release it, which will be completely different to what you've actually talked about.
Yes.
The Minister will have decided something very different.
I'll have to rewrite my PhD thesis, no doubt.
So we'll look forward to it getting in first.
Yeah.
And otherwise, thank you everyone, and we'll catch you all next time.
Thanks for the questions, Bruce.